Hi friends from around the world, this is about patents. Today, let me see, the European Patent Office is not a community office. We don't have a unitary title in patent, you all know this. What we still have is the intergovernmental organization of the European Patent Convention with the EPO in Munich as being the managing agency. And what we have in the sequence of a patent life, so to say, we have the filing and we have the opposition and then we have the boards of appeal. But what we don't have, like in trademarks, is a judicial instances behind, like the Unified Patent Court, which will come together with the unitary patent. We were still waiting for this. Now, an anonymous or strawman opposition. So if you're coming from trademarks, you would not know what that is or what the value of that could be, because it is not very current. In fact, I have worked on trademark a long time. I never came across of a strawman opposition, although the possibility still exists, because there are oppositions where you don't need, namely in absolute grounds, where is non-distinctiveness or deceptive or whatever, offensive, there you don't need to have to present a personal interest or an earlier right or whatever in order to present a opposition. It is rather that you obey to public interest. And so everybody can present such a opposition. But as I said, I haven't come across. Now, in patent, there may be strategic considerations behind, and I will come at the end of the presentation to it, which may suggest that you make an strawman opposition, yet you opt for this possibility rather than to identify your client fully in the proceedings. We will come to that. Now, let's come to the case. It is about Boards of Appeal decision from the EPO. Here it is on the screen, and it is from April 2021. It is about Nestlé. Yes, that is the coffee maker here, which is the filer of the patent and has been granted in 2018. And it was opposed by an individual in Spain. In fact, it was an owner of a garage in Valladolid, an individual. So just for the completeness, the patent has a coffee machine, a flavored baked-in machine for coffee or for juices or so. That is what it was about, but it has no bearing on the case. Now, what happened with the opposition division in EPO? They considered that the patent was not fully granted. There were some issues, so it was granted in an amended version only. Whereas Nestlé said the opposition was inadmissible. So the admissibility argument has been rejected by the opposition division, and Nestlé went to the Boards of Appeal of the EPO in order to get granted fully the patent. And it argued mainly that the opposition was inadmissible because the individual, the person in Valladolid, it had no interest, no bearing in the case. It was so a strawman acting for somebody else, and that would be against Article 6 of the Human Rights Convention. Now, the Board of Appeal took up this case, and on the admissibility, there was already a case decided in 1997 from the Grand Board of Appeal on that, and it repeats over some pages what was the reasoning of that board decision. And the reasoning was, in fact, that the opponent is a procedural party of the proceedings in front of the EPO, and according to Article 99 and 100 of the European Patent Convention, it is not necessary that the opponent has a personal interest in the case. It is just a person that must be identified as such as the opponent, but no additional requirement are necessary so that this opponent can figure, well, as such as an opponent. With regard to the Article 6 of the Human Rights Convention, well, this is only saying that the opponent in that case, so the part of the proceedings, that must have a fair trial. So here was a hearing granted through video conferences, etc. So a hearing was granted, and there is nothing. So the party, the opponent, had a possibility to explain itself, defend against whatever argument has been brought up. So a fair trial was. So there was no contravention against this, meaning that the boards of appeal, they confirmed the decision of the opposition division. You have anonymous decisions, right? Anonymous opposition decision. So it's not anonymous, it is a strawman decision, because anonymous, they must be identified, though there is an opponent, there is an identification of the opponent, but there is not the, so to say, the real opponent. It is a strawman who introduces the opposition. It is not the one with the real interest. Now, what are the strategic considerations which might give you the possibility, or might opt for you as a counsel to give the advice to your client by saying, well, why do not do a strawman opposition? And then you have to explain it, what that is to your client, right? So the first would be the possibility that you reduce the risk of retaliation. So if you are openly acting against somebody, that somebody like Nestlé, they may you harass on other issues, they may against you, they may go against you, against I don't know, other patents, or introduce I don't know, whatever kind, or commercially they may come with some issues against you. So if there is anything when you see that the patent owner may come after you in order to put commercial pressure on your client, then that would be a possibility in order to opt for the strawman opposition. Or avoid retaliatory oppositions against your own, maybe trademark, but we are talking about patents here. It is about the patents. If you have a patent or if a trademark, you may want to avoid that it to become under commercial pressure for having filed an opposition against a patent granting of a competitor. Or avoiding commercial relationship problems with the patent owner. So if it is that you are already in commercial relationships with that patent owner, but you want to opt, or that contract, for example, prohibits you from getting into a relationship with other actors, market actors, then you don't want to give a kind of indication to the patent owner that you are dealing with others or you want to deal with others. So you may opt that the patent owner will not get your real identity, so they do not get into thinking what happens with you now. Or, for example, to improve the negotiation position with regard to the patent owner. So if you are interested in that patent, or you have a competing patent which you want to sell or whatever, well, that's not a good idea. But you want to acquire that patent, and you put in opposition against that patent. And you want to make an offer in a parallel way. So you would say, well, the patent is under pressure, so I don't know whether the patent will be upheld or not. So that has an influence on the price, right? So that would be a strategic consideration as well. The freedom of estoppel. So the estoppel is a kind of venire contra factum proprium, the estoppel in American law. That is your arguments, what you advance arguments that can be held against you in other proceedings. So you can be stopped from arguing in this if you have argued in the contrary in other proceedings, so to say. So if you are not part of the proceedings, as is the case with strawman, so the strawman is part of the proceedings, you are not, then the strawman can argue whatever is necessary in order to win the case, but you are not bound by it. It is not a burden on you as the real party, so to say, of the opposition proceedings. And you may also hide interest in a technological area where, well, you will not give hints to the competitor, to this competitor or to other competitors, because it will be in the public register that you made this opposition. You do not want to give hints to the competition where you are interested in. What is your direction with regard to technology area where you want to compete in the future? So that would be also an idea where you would say, well, I can opt for a strawman opposition rather than expose myself in the opposition proceedings as such. Now there's a different argument. It is rather circumstantial, but or practical. You know, here in that case of Nestle, there was a video conference, a hearing. So it is not in-person hearing. Well, we are in a pandemic, so why would we do in person? But that might still be maintained in the future. Now, if you have a video conference, you can be with the strawman, so to say, in the same room, and you can listen into the argumentation which is being exposed in the hearing. So it is a possibility for you to engage with the lawyers when they want to argue on this and on that. So you have additional possibility to get influencing the case. So this is what I wanted to tell you. Well, just to be clear, we want also to have this possibility in the Unified Patent Court once we will have it ratified by Germany in that case. So this strawman opposition, once you will be opponent in the proceedings before the EPO, you automatically also are qualified, naturally, for being defendant or claimant in an action in front of the UPC. So this is timeless. This is not something which is now for that moment or for EPO only. It will be for the Unified Patent Court as well. So that's it for today. The patent, anonymous patent or the strawman patent. I think it's exciting, isn't it?